Good afternoon, Madam President. I rise to raise some points on the bill that is before us. I'll note that we had a similar bill before the Senate last year, and I did support it. And I've struggled with this since we started debating it a little over a week ago, reading through the different variations of the bill and asking questions in caucus and understanding changes as they've been made to the bill along the way. Because I want to be comfortable with what we're doing here. The folks that have spoken before me have spoken very eloquently and very passionately about the emotion behind this particular policy that's before us. And I feel certainly the same way, except I don't want to get wrapped up merely in the emotion and the importance of addressing domestic violence. We also have to look at the other ramifications of the legislation that is before us. I think everyone in this circle absolutely condemns domestic violence, and we all want to work together to make sure that people that engage in that behavior are punished and that victims are made whole and protected. And I'm certainly on board with that. The issue I have is that this bill, in an attempt to protect the victims of domestic violence from experiencing coerced debt, I think are creating potential avenues for fraud. And I believe that ultimately we are misplacing some of the penalty, not on the abuser or person that is doing the coercing, but on an innocent third party that is engaged in a perfectly legitimate contractual agreement. I'll just lay it out in plain terms. And that is that what we're talking about is a situation where a person is coerced by another person to take out a loan, maybe for a car or a house, or engage in a rental agreement, something like that, because they are pressured by another person to do so. And I would absolutely agree that the person doing the pressuring is a bad person, and we need to punish that person for that activity. And we also would like very much to protect the victim in this particular case. But what about the person who made the loan? The fact of the matter is that they've done nothing wrong, and that I believe in this particular bill there are circumstances that are going to lead to those folks that engaged in those perfectly honest transactions being the ultimate losers. So instead of creating a solution to punish an abuser, what you are ultimately doing is creating yet another victim. You're creating two victims. You have the victim of the coercion, and you have the victim who is going to be financially harmed by not being compensated for what they have loaned to someone else perfectly legitimately. And I don't know why my colleagues are failing to see that these are two separate transactions. The person coercing the person is wrong. That is an issue. But the person who is taking out the loan or borrowing the car or signing the rental agreement is also engaging in a transaction that is completely separate. And the person on the other end of that transaction has no part of the coercion. None. They're not involved in that. And they should not be held to a standard where they are going to suffer the consequences, in my view. Now, I want to say that I know that a lot of work has gone into this legislation, and I know that my colleagues have worked very hard to try and tighten this up, to try and make it so those folks that I'm referring to, the lenders in this particular situation, who are referred to throughout the bill as the claimant, because ultimately they're the ones claiming to get their money back. I find it odd that we worded the bill in this kind of framework, but nonetheless, the lender, in my view, needs to be made whole. And the concern I have is that when this bill passes, it is not so tightly written that it is going to end up preventing those folks from losing out. And that's what I would like to see happen. I don't want to create any more victims than we already have. Madam President, I have a few questions for the proponent of the bill, if I could.
Yes, please proceed. Prepare yourself, Senator Miller.
Thank you, Madam President, and good afternoon, Senator. I want to sincerely thank you for your hard work on this bill, and I'm extremely sympathetic, and I'm trying to get to a point where I can support the legislation before me. And a lot of that will hinge on some of the questions that I ask and what you tell me. But the first thing I'd just like to talk about is the definition of coerced debt, which appears on lines 18 through 22. And I noticed in there it defines coerced debt as debt when such debt was incurred in response to any duress, intimidation, threat of force or undue influence used to specifically coerce the debtor into incurring such debt. Now, intimidation and threat of force, I think, are good words. And I think that if you have those words in there, now we're talking about somebody who's absolutely engaging in some sort of threat of violence. But the words duress or undue influence concern me because, well, let me ask this question. Through you, Madam President, can I have an example of what might be considered undue influence through you?
Senator Miller.
Thank you, Madam President. Through you, undue influence would be, in my opinion, through you, Madam President, is when, first of all, let me say that this bill applies to a domestic violence victim. And so that person is intimidated through you, Madam President, and that person is afraid of their abuser. And so when we talk about undue influence, anything that abuser would do or say, they're influencing and is undue. So I think that we need to understand, Madam President, that when we talk about force and undue influence, it's that the abuser is influencing this person, influencing the victim to take out the loan. Through you, Madam President.
Thank you, Senator Sampson.
Thank you, Madam President. I appreciate that answer. And the only thing I would suggest is that nowhere in this bill does it indicate that this bill affects only domestic violence victims. Can the good chairman point to where this bill applies only to domestic violence victims for me, through you?
Senator Miller.
Through you, Madam President, the bill refers to coerced debt. And if we look at line 18, the definition, it says coerced debt means any debt incurred in the name of a debtor who is a victim of domestic violence. Through you, Madam President.
Senator Sampson.
Thank you very, very much. I appreciate that. And I'm glad you pointed that out to me, that we are only referring to coerced debt for victims of domestic violence. And I imagine that is more appropriately defined in the section that is mentioned on line 20. I was looking at where it says that the debtor, who is the person referred to throughout this particular bill, on line 32, just says an individual against whom a claimant asserts a claim arising from coerced debt or allegedly coerced debt. That being said, does this language mean that someone would have to have an established situation that's documented as a domestic violence victim, or can they just simply state that they are a victim of domestic violence? Through you.
Senator Miller.
Through you, Madam President, the bill points out what the debtor must do in order to claim the coerced debt.
Senator Sampson.
Thank you very much, Madam President, and I appreciate that answer. What I'm trying to get at really is a situation that tightens this up so that we know that the person that is claiming that the debt is coerced was in fact coerced, and whether or not this particular language really rises to the level where I think a person on the street would agree with that. You know, I mean, when I see undue influence, you know, I'd say, like, you know, my family might have undue influence on me when they tell me to make a financial decision because I'm feeling some peer pressure, etc. But that's a whole different thing than domestic violence. as described by the good chairman, and includes intimidation or the threat of force, something like that. Undue influence to me is a very vague term, and that's why I'm raising the concern. Is I just want to make sure that we are truly defining what we're after here in the bill. But I'll move on to another section. So, is there anything in this bill, through you, Madam President, that punishes the person doing the coercing, through you?
Senator Miller.
Through you, Madam President, the courts must determine that the debt was coerced, and there is no punishment for the person committing the coerced debt. But it does state that the coerced debtor must be a part of must be a party of the action. Through you, Madam President.
Thank you, Senator Sampson.
Thank you, Madam President. Well, I appreciate that answer. I just want to make sure I understand, the kind of the process here, which is that, so I am in a scenario, say I'm someone who is coerced by another person into, taking out a loan for a home. Several years later, I get the courage to contact the lender and say, I cannot make the payments on this particular home anymore. I should not have taken out the loan. It was a result of the fact that the person that I was with, pressured me into it. They intimidated me into it, very legitimately. At that point, what happens? Does the lender automatically stop charging the person, or do they have, or is there a requirement on me to make a case that that I was coerced into taking out the loan? What was the process? Through you, Madam President.
Thank you, Senator Miller.
Thank you, Madam President. Through you, Madam President, it is the debtor can either verbally, orally, or in writing ask the claimant, the creditor, to notify them of the coerced debt. They're required to submit certain documentation, and they have to certify. So it could be a police report. It could be from a third-party professional. So they have to prove that there is coerced debt, and they also ask the creditor to stop the action, to stop the collection activity. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. I notice I think it's still in Section 1, on line 69, or let's say 67 through 69, it says that the debtor has to provide the claimant with documentation certified by the debtor, as you just mentioned. It says includes the following, and then there are a list of items here. And I am just curious, through you, Madam President, does this mean that all of the items that are specified, starting with little I to double little I, triple little I, and so on, do those all have to be part of this documentation, or they only have to provide one or maybe additional pieces? Through you.
Thank you,
Senator
Madam
Miller.
President. I'm sorry, Madam
You're
President.
fine.
I jumped the gun.
Senator Miller.
I apologize. So on line 67, it says the debtor must provide the claimant documentation certified by the debtor that includes the following. And then it goes through a litany of items that they must provide to the claimant. And so that could include everything: the telephone number, their address, police reports, restraining orders. So yes, Madam President, it is most all of that.
Senator Sampson.
Thank you very much, Madam President. So all of these items are required in order for this debtor to go ahead and cause the lender, the claimant, to stop the collection of the debt. The debtor has to provide all of these items. Am I correct about that?
Senator Miller.
Through you, Madam President, I thank my colleague for asking that question again. So through you, Madam President, there is certain information that they have to provide about themselves. As far as the support documentation, which is on line 1, the attaches not less than one of the following, which is on line 101 and 102.
Senator
And that is the police report, Madam President, and any other restraining order,
Senator
et
Sampson.
cetera.
Thank you very much, Madam President. I appreciate that answer. It's very, very important to me to clarify that the items preceding subsection B, which you just referenced, that the debtors required to include all of them. I notice in subsection 5, little v, it says the identity of the individual whom the debtor alleges coerced the debtor into incurring such debt. This is what they're providing to the claimant for those listening. If the debtor knows such contact information. And then it says, unless the debtor signs a sworn statement that disclosing such information is likely to result in abuse to the debtor or any immediate family member. Now, I'm very sympathetic to this. I completely understand, that somebody might be in a very difficult position and they don't want to, tell on or rat on the person doing the coercing here for fear that there'll be some sort of retaliation if the lender, the bank, whoever goes back to that person. But my concern here is that by doing this, we are putting the actual lender at a disadvantage because I believe this means that the debtor does not have to provide the information. Am I correct about that?
Senator Miller.
Through you, Madam President, that is correct if the debtor feels that their life is in jeopardy. Through you, Madam President.
Senator Sampson.
Well, I appreciate that, Madam President, and I thank you very much for the answer. And again, this is such a difficult topic, and it's actually very hard to even talk about because I want to be understood very clearly that I am very much in favor of what we're attempting to do here. I'm just very concerned about the potential unforeseen consequences at the same time. It appears that, Madam President, can we stand at ease just for a moment?
And we can stand at ease because I do believe.
I think we were talking a little bit about the concerns that I have regarding the actual lender involved, and just concerned that there's a potential here where the person who is doing the coercing, the abuser, who we want to get after, is not going to be punished. Is there, the way I'm looking at it, it seems to me, based on the language of the bill, that the debtor has some responsibilities to the bank, the claimant in this particular language, to point out what happened and who the person was that was coercing the debt, et cetera. But they don't have to do that in all cases whatsoever. And in fact, we pointed out a situation where, a very terrible situation, where the person could be fearful about reporting that person. And that's a perfectly legitimate and understandable thing, except if that happens, I foresee that the claimant is not going to be paid back. Is that your understanding as well, through you, Madam President?
Sorry about that, Senator Sampson. Could you repeat what you just said?
Thank you, Madam President. Oh, that's that's asking a lot, but I will try. I was just discussing a particular situation where we described the requirements for the debtor, the victim, the person who is being coerced. They have certain responsibilities back to the lender to explain the reason why they are unable to pay the debt, and they need to respond providing the information about the abuser, the person that had coerced them into the debt. And that makes perfect sense. But there's an exception in the bill, which I agreed with completely, which says that if that person is scared, if they're intimidated, they do not want to share that information for fear of retaliation, that they don't have to. And all that makes perfect sense, except it leads us to the next question, and this is the question I would like to ask through you, Madam President, and that is that a circumstance where the claimant, the lender, the person who provided the funds, they're unlikely to be paid back through you.
Senator Miller.
Thank you, Madam President. Madam President, if the debtor takes the claimant to court and the judge rules in favor of the debtor, the claimant has the opportunity or the ability to file suit against the debtor, the coercer.
Thank you.
And they have, I'm sorry, Madam President, they have up to 5 years after the decision. Thank you, Madam President.
Thank you. Senator Sampson.
Thank you very much, Madam President. I heard the gentle lady's response, although that's a different situation. I'm asking about a situation where the debtor, the person being abused, the victim in this particular case, they're telling the creditor that they cannot share the information of the coercer. So how can the bank now get the money? How could they file an action within 5 years, as you said, through you?
Senator Miller.
Through you, Madam President, in the debtor's request, they are required to give as much information about the account. If the claimant decides that the debt was not coerced, the debtor can then go to the courts, file an action in the courts, and again, it's during that time that the claimant can go after the debtor.
Senator Sampson.
The coercer of the debt.
Sorry about that. Senator Sampson.
Thank you, Madam President. And I am sorry, but I'm going to ask this question a third time because I keep getting the same answer, which is that the bank, the claimant, can go after the coercer, but if they do not have that information, if they are not provided with the information to say who that person even is, how can they collect those funds? Through you. Senator
Miller.
Through you, Madam President, according to line 89, starting in 85, unless the debtor signs a sworn statement that disclosing such information is likely to result in abuse to the debtor or any family member of the debt, except the debtor shall disclose such information in the event that the claimant gives notice to the debtor that the claimant is ceasing collection activities against the debtor under this section and releasing. So, through you, Madam President, if the claimant is saying that they're going to cease the action against the debtor, then the debtor can release that information. Through you, Madam President.
Senator Sampson.
Thank you very, very much, Madam President. I read this section too, but is this is supposed to indicate that a trade can be made through you, Madam President, that the creditor, the claimant, I'm using so many terms here, it's hard to keep the people straight, the bank, the claimant in this language, if they agree to write off the debt completely, they would do that in exchange for the debtor providing the information about the coercer. Is that what I'm understanding based on the language you just read to me through you?
Senator Miller.
Through you, Madam President, I don't consider it an exchange. I think the law is very explicit, or the bill is very explicit, to say that when the debtor alleges coerced debt, that the debt and the debt contact information can be given, except in those cases where they feel that their lives or their family life is in jeopardy.
Senator Sampson.
Thank you very, very much, Madam President. And I apologize that, I think this is, some complex situation involving numerous parties, and it's hard to discern exactly what's going on in some of these paragraphs in the bill language. But I guess what I'm asking is there ever a situation where the bank, the claimant, is required to cease collection activity without being provided with the information necessary to collect the debt? Through you.
Senator Miller.
Through you, Madam President, I can't answer that question except for what it says in the bill. If the debtor feels that their life is in jeopardy, they do not have to disclose that information. Otherwise, they can disclose the information. Through you, Madam President.
Senator Sampson.
Thank you, Madam President, and I thank the gentlelady for her response. And again, I hate to be so particular, but the language that is in the bill is what we're talking about. Nowhere in here does it say anything about someone's life being in jeopardy. It says the debtor signs a sworn statement that disclosing such information is likely to result in abuse to the debtor or in any immediate family member. And certainly that could be the same thing as feeling that one's life is in danger, but it doesn't rise quite to that level either. And it's quite clear from this conversation that indeed there are situations where the person who actually took out the made the credit card charge or something like that can report to the bank and say, look, I'm not going to pay it back because I was coerced into this debt, but I'm also not going to provide the information to the bank on who coerced me because I'm still intimidated by them, leaving the bank with no way to recover their damages. And that's the way I understand this section of the bill. And if I'm wrong about that, I'd like to be corrected. Through you, Madam President.
Senator Miller.
Through you, Madam President, I can only say that the banking industry was a partner in drafting this language, and I believe that if they felt that there wasn't a way of them collecting their monies, that it would have been indicated, something different would have been indicated in the bill. Through you, Madam President.
Senator Sampson.
Thank you, Madam President. Is it the good chairwoman's testimony, effectively, that the banks involved asked for this legislation? Through you,
Senator Miller.
Through you, Madam President, the answer to that is no.
Senator Sampson.
Yeah, thank you very much, Madam President. I'll just, as an aside here, and again, I don't mean to get off on a tangent because I don't want this to be a conversation other than a conversation about getting to a full understanding of what the ramifications of this bill is. And I am very supportive of the idea behind this bill. No one in this circle is trying to aid people that are domestic abusers. And the fact of the matter is we would all like to find ways to punish people that engage in harmful activity. And I certainly count myself among them. But I also don't want to see innocent people be harmed in our effort to create a policy protecting a victim. And I believe that's what's happening. Because several things are going to occur here. One thing is that if you leave the bank with no way to collect their money, they're going to be harmed, right? They're going to be harmed. And if they choose not to be harmed, the way they will choose not to be harmed is simply to raise fees and costs and interest rates for the rest of the world. So we will be creating more victims. Again, the problem I have with this bill is it does not go after the actual person causing the problem. All it does, while it is effective at protecting the victim, and I'm fine with that, the problem is that you're protecting the victim by creating another victim, and that is the lender or whoever they pass the costs on to. It does not actually impact the coercer, except in cases where we can actually narrow that down. If that was a requirement of the bill, that the person doing the coercing absolutely was going to be held responsible and must pay back as the primary source of funds, then I would have no problem with this bill. But effectively what we're going to do is we're going to suggest that someone who took out a loan, maybe in the process of being coerced, or they put items on a charge card, that they're going to be absolved from having to pay that back because they were coerced. That's a legitimate argument. But what about the guy who's supposed to receive the payment for that? That's the concern. I just want to just add to that conversation that all of this assumes also that the person doing the coercing actually would have the ability to pay back the loan or the payments to the credit card or whatever. And I suspect that's not the case. I believe that, you know, if someone is coercing, you know, a spouse or you know, a boyfriend or girlfriend or something like that into taking out these, you know, financial obligations, they're doing it because they can't do it themselves. You know, probably because they don't have access to the money or the credit to be able to make the purchases, which is why they're forcing someone else to do it. So when you turn over and say, well, we're going to tell the bank, you got to get the money from this other person, well, the bank might never have actually given that person that credit. There is a reason why in our society we allow the freedom of individuals to engage in commerce selectively. It's because that way they get to choose who they're going to offer credit to. It's like, it would not be fair for any of us to be able to go to any creditor that we owe money to and say, well, I'm not going to pay it back. I'm going to have so-and-so pay it back. That's not up to us. The bank needs to agree that that person is actually eligible and able to pay it back before they would ever do that. If anyone's ever tried to roll over a car loan or a home loan to another person, you'll know exactly what I mean. They don't just say, okay. They would have to do a full background check and credit check of that person too. And I believe that in this situation, we have a very high likelihood that the person doing the coercing is also not able to pay. And again, I've been repeating myself a lot today, and I don't want to do that, but my concern here is that we're creating an additional victim rather than addressing what I consider to be the real problem, which is to go after and punish people that engage in domestic violence and deter that from happening, period. I want to say a word about the banking industry too, and that is that, look, I didn't have any interactions with any of the participants in the drafting of this bill or this amendment or anything else, so I don't really know anything that happened. But I do know that very often it is said in this building that you know, the business groups are on board or the banking industry supports this and everything else. They may, in fact, say that we support this language, but that doesn't mean that's what they want. I think that more likely they're being coerced into having to accept some sort of bill, and this is the one that they find to be least toxic. So they're going to say, okay, we support this language from our perspective. But I would also suggest that that type of coercion is not acceptable either. And I also don't agree necessarily that if they were not responsible for actually requesting this language, that it should be represented that they are in favor of it. Are there any, so I have several direct questions. What if the funds are not collectible by the claimant from the coercer? What happens then, through you, Madam President?
Senator Miller.
Thank my esteemed colleague for the question. Can he repeat it, please?
Senator Sampson.
President, the question is, what happens if the funds, the borrowed money that the abused person borrowed from a credit card, let's just use that as an example for going forward. An abused person who was coerced into putting items on a credit card for another person doesn't pay back the debt. They go to the credit card company and say that this is the person that coerced me into it. They're the ones that are responsible. What if that person is unable to pay back that money? What happens then, through you?
Senator Miller.
Thank you, Madam President. Madam President, is my Senator Wong pulled the, took my mic apart. Thank you, Senator Wong. It's my understanding, Madam President, in the state of Connecticut, if there is debt that is uncollectible, the creditor then proceeds with collection activities. They report it to the credit rating companies, agencies. They hire a collection agency to collect the debt. Through you, Madam President.
Thank you. Senator Sampson.
Thank you very much, Madam President. I completely understand. What if the situation is that the person, the abuser, has poor credit already and has no job and they have no ability to pay? What happens then? Through you.
Senator Miller.
Through you, Madam President, whatever their procedure is for someone other than a coercer or a debtor, that is still the same procedure, is my understanding. And I know of people where the bill collector calls the house and says, I'm dealing with a constituent now, where there is a debt and the collection agency is trying to collect on that debt. They want information from that person. I also know that creditors and collection agencies take individuals to small claims court and wages are garnished, and if they don't have wages, whatever deal or judgment that the courts decide on, then that's what the person has to do, whether they have income or not. So I can't answer that question as to what if the person didn't have a job. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the gentlelady's answer. What I'm trying to illustrate here is that by virtue of this legislation, if it becomes law, we may create a situation where we have taken a perfectly honest person conducting a perfectly legitimate business and effectively denied them the ability to receive repayment on credit that they've offered to an individual, because we have denied them their ability to collect from the individual and instead have instructed them to collect money from someone they never would have approved to begin with. Now, for me, I don't think that's fair. I don't think that's just. I don't think that that's what this body should be up to. I agree with the notion that we should punish people that engage in domestic violence. I also believe that we should try and protect people that are harmed or abused. And if the state of Connecticut wants to create a fund to help out people that have coerced debt, I might even support that. But the idea that we're going to take and tell someone who entered into a business agreement in a perfectly lawful and legitimate way and followed all of the required laws in the state of Connecticut for doing credit and background checks and so forth, and they engaged in offering credit to someone, they should be eligible to collect their debt. They should be made whole. And this bill does nothing to make those people whole, nothing at all. It effectively says, well, we're going to try and set up a system where you can attempt to get the money back. And it was just described to me, court and, collection agencies and things. Those things cost money. Those things cost money. So we are telling the lender that they have to engage in a costly process to recover money that they are owed from someone they never lent money to. This is why I have a problem with this bill. Because as I started from the beginning, these are separate situations. You have the person who is abusing someone and coercing them into different types of behavior, including taking on debt. That is one situation. It is a big problem. I would like to solve it. But the other situation is that person, that same person, was taking out a loan from someone else. Maybe the reason was because of the coercer, but the person that gave them the credit doesn't know that. They have nothing to do with that. That is not their problem. That is not their responsibility. We are making it their problem. So why are we creating a new victim, is what I want to know. That's what I don't like about this bill, is we are creating a new victim. I think people on the street, when they hear about this, are going to come to the conclusion that the fact of the matter is that while this is very important and it can be used in legitimate situations, it's also ripe for the potential for people to abuse this situation by claiming that they were subject to some sort of coercion so they don't have to pay a debt. And my concern about this is that this right now is for unsecured debt. It's for credit card payments. It could be used for a rental agreement, which is what concerns me maybe more than anything, because this means that we could get into a couple could get into a lease agreement, and one person is coercing the other person into engage in the lease, and then they disappear. And now that person's going to claim that they don't have to pay back the landlord. Well, but the landlord didn't do anything wrong. Why can't they be paid? Again, if the state of Connecticut thinks this is so important, then the state of Connecticut should set up a fund to pay off this coerced debt, not to tell other people that they are not deserving of what they're owed. I have a bunch of other notes, but I'm going to get right to what I think is the heart of this matter, which is that I heard a lot of very passionate comments from my colleagues, members in both parties, talking about the terrible nature of domestic violence, and I agree with them wholeheartedly. But the fact is that this bill does very little to punish people who engage in domestic violence. In fact, it may create a mechanism where they may ultimately be responsible for debt, but not in every case by any circumstance, and not until after a whole bunch of steps are made. What I would like to see, Madam President, is a bill that actually punishes people that engage in domestic violence. So with that, I have an amendment. It's LCO 4439. I ask that the clerk call this amendment, and I be given leave of the chamber to summarize.
Mr. Clerk.
LCO number 4439, Senate Amendment C.
Senator Sampson.
Thank you very much, Madam President. This is a very straightforward amendment. It would create a new section that says that a person would be guilty of coercion of debt, a new crime, effectively, when such person, for such person's use and benefit, knowingly uses intimidation, threat of force, or undue influence, the same words that are in the definition of coerced debt, to cause another person to incur any debt. It goes on to say that this will be an affirmative defense to be used in a prosecution based on a coerced debt situation as described in the underlying bill. And then it also says that this new crime that we're creating here would be a Class A misdemeanor. This is a very simple amendment. A very simple amendment. If you believe that we should create a crime of coercing someone into taking on a debt, that should in fact be a crime that should be punishable under our laws in the state of Connecticut, and to be used as a deterrent to prevent this from happening, or a punishment for those who engage in that behavior. Very simple amendment. If you vote yes, you will believe in punishing the abuser, the person doing the coercing. If you vote no, I guess you don't. I move adoption, and I'd like a roll call vote. Thank you.
Thank you. We'll have a roll call vote. Would you like to remark on the amendment, Senator Miller?
Thank you, Madam President. Madam President, I appreciate my esteemed colleague's position. I ask that my colleagues vote no on the amendment.
Thank you. Will you remark further on the amendment, Senator Harding?
Thank you, Madam President. I do rise in strong support of this amendment. I believe it highlights how important it is to address, also the focus on the individual, the coercer. And as Senator Sampson alluded to, and he did a very good articulate job of doing this, is that there's one aspect of this bill which is positive, which addresses the victim, and for liability purposes and for other purposes protects the victim of this terrible act in which an individual has coerced them into debt. And it does protect them, and that's a positive thing. But what this does is, in addition to that, so it doesn't take any of that away, it focuses the good aspects of the bill that protects the victim in these particular cases. And then what this does in addition to that, and I want to thank the proponent for bringing this out, is that it makes it a crime and focuses also, in addition, on the individual that's committing this act on the victim. If we believe in addressing, domestic violence and things that are terrible and heinous, of coercing individuals into debt, then we should believe in supporting criminal actions that would hold these individuals, these perpetrators, accountable, criminally accountable, for coercing an individual into these terrible, horrible situations, using the tactics, these terrible, horrible tactics that we've already been addressed in this chamber today, that it should be a crime. And I want to thank the proponent of the bill for highlighting that. An individual that uses these actions in a threatening manner, in a domestic violence situation, I would argue these are criminal actions. The good thing about what this amendment does is it takes all the good parts of the underlying bill that protects the victim, and then also puts a new focus on punishing the individual that's perpetrating this upon the victim, and criminally. So I support this measure. I want to thank the proponent of the bill for bringing it out and giving us the opportunity, again, to focus on helping the victim in this matter, and in addition to that, punishing the individual that forced the victim into this particular situation. So again, I rise in strong support of this amendment. I urge my colleagues to do the same. Thank you, Madam President.
Thank you. A roll call vote has been requested, so we will do that. But first, I will see if anyone else would like to remark on the amendment before the chamber. If not, I will open the voting machine. Mr. Clerk, announce the vote, if you will.
Immediate roll call vote has been ordered in the Senate. The immediate roll call vote has been ordered in the Senate. We're voting on Senate Amendment C, of substitute for Senate Bill number 123 as amended. This is a vote on the amendment. This is Senate Amendment C. We're voting on the amendment, not the bill. This is Senate Amendment C.
All the senators voted. Mr. Clerk, would you announce the tally on the amendment, please?
Senate Amendment C of Senate Bill 123. Total number voting 35. Total voting yea 11. Total voting nay 24. Absent not voting 1.
Amendment fails. Will you remark further on the bill before the chamber? Senator Sampson.
Thank you very much for the recognition, Madam President. I have to say I am completely and utterly shocked. I offered an amendment that I thought, listening to the early conversation about the bill before us, would be a slam dunk amendment, that there is no way anyone in this chamber couldn't possibly agree. The amendment that I just offered was very straightforward. It simply would create a crime out of the activity of coercing debt through domestic violence to a victim of domestic violence. It shocks me. If folks in this chamber are so adamant that they want to protect the victims of domestic violence, that we create the bill that is before us for the express purpose of protecting those victims, why on earth would we not want to punish the people committing the act of domestic violence? I've been thinking this afternoon, during the debate and in offering that amendment, that if the amendment was adopted, I could at least justify a yes vote on the underlying bill, recognizing that we are taking a step forward to actually combat domestic violence. But I don't believe we're doing that with the underlying bill. I believe that in some ways we are protecting the victim of domestic violence, which is a good thing, but that is not the same thing as combating domestic violence. That is not the same thing as preventing domestic violence from occurring to begin with. That does not do the same thing as preventing coerced debt from occurring either. And the bill that's before us has a million holes in it. I'm afraid it just does. And if you start to talk to people on the street, they're going to understand completely what I'm describing when I say that this does not go at the problem. You are effectively creating a new set of victims with this legislation. Not only do we have a bad situation where someone is coercing debt through domestic violence, but now you're creating a situation where the ultimate payer, the creditor that loaned the money for the coerced debt, has a very high probability of never being compensated for that. Now, how is that fair? It's not. It's just not fair. It's not what we should be doing. If we have a problem in our society, we should tackle the problem head on. And if the problem is domestic violence, then we should tackle domestic violence. We should create a crime for coercing debt. I was shocked to find out there was no such crime, which is why I offered the amendment. I was like, I can't believe that this has only got a civil penalty. How could we not have a law on the books already? How could we not already have a law on the books that says that it's a crime to cause someone to take on debt through coercion and domestic violence? There deserves to be such a law, and I can tell you, Madam President, I will be back, and the next bill that I come across that actually is a good vehicle for that, I'm going to offer this amendment again. And I'll be back next year to propose this bill again because it's a good idea. I am very disappointed that that could not be adopted as part of this legislation. And now I'm left with a very difficult decision because my heart is telling me to vote yes for this bill because I feel for the many people that put work into this because they believe that that is actually going to help victims of domestic violence. But my brain is saying, don't do this. This is a problem. This is a problem. You are creating a situation where there is now a mechanism to avoid the repayment of debt that doesn't allow the ultimate lender, who had no part in any crime or violence or any evil behavior whatsoever, they are ultimately the victim in this. And further than that, we all become victims because that cost will be passed on to every one of us in some way, shape, or form. That is not the solution here. I guess there it is, Madam President. My reason is going to win over my heart in this particular case because I just cannot justify creating another wrong by creating another victim in the process of passing this bill. What I really wanted to see happen was something concrete, something that we could put our hands, firmly around to say we did something today to stop the act of coercive debt via domestic violence. That would have meant something to me. That would have meant something to the people of Connecticut. That would have meant something to the people experiencing the terrible act of domestic violence if we actually created a crime for this activity. Thank you very much, Madam President.
Thank you, Senator Sampson. Will you remark further on the bill? Will you remark further on the bill? If not, the machine is open. Mr. Clerk.
Amended by Senate Schedule A and B. An immediate roll call vote has been ordered in the Senate. We are now voting on the bill. We're voting on the bill.
Senators voted. The machine is locked. Mr. Clerk, please give us the tally.
Substitute for Senate Bill 123 as amended by A and B. Senate A and B. Total number voting 36. Total number voting yea 35. Total voting nay 1. Absent not voting.
Legislation passes. Mr. Clerk.